Welcome back, America, to another edition of Honest Tax Returns. Since 2016, I've made a website documenting an ebook, and this ebook may be found at the lawfultaxavoidance.com website. This video is Honest Tax Returns Part 14.5, Defects in IRS CP504 Notice of Intent to Levy. And now for the artificial not-so-intelligent narrator.
If you have received IRS Letter CP504, Notice of Intent to Levy, then you may find this helpful. This video, Honest Tax Returns, Part 14.5, Defects in CP504 is a follow-up to a video posted on April 20, 2021 called Honest Tax Returns, Part 14, Notice of Intent to Levy, which documented a true story of Big Daddy's correspondence with the IRS. In March 2021, Big Daddy received his first IRS letter CP504, Notice of Intent to Levy, for tax year 2017. He replied in April 2021 using a letter similar to the one narrated in the Honest Tax Returns, Part 14, Notice of Intent to Levy video. There was no substantial movement on this issue until September 2025, more than 4 years later, when Big Daddy received a second IRS letter CP504, Notice of Intent to Levy. After further studies, Big Daddy issued a response in October 2025, detailing the 5 reasons why the agency's intent to levy is defective. Reasons 1 through 3 are based on a strict interpretation of 26 U.S. Code Section 6331. Reason 4 is based on the difference of terms between Article 4 and Amendment V of the U.S. Constitution, and the 5th reason is based on the public rights doctrine, and the inherent difference between administrative and judicial powers. Let's start with reason number 1. 26 U.S. Code Section 6331 states in part, levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States. Thus, no levy may lawfully be executed against me, as I am not an officer, employee, or elected official of the United States, nor may it be executed upon my private property. Reason number 2. For the purposes of the levy under Section 6331, of the person is defined by Section 6332, f, to include an officer or employee of a corporation or a member or employee of a partnership, who as such officer, employee, or member is under a duty to surrender the property or rights to property, or to discharge the obligation. Thus, no levy may lawfully be executed against me, as I am neither an officer or employee of a corporation or a member or employee of a partnership, nor do I have any duty of such an officer, employee, member, or partner. Reason number 3. For the purposes of the levy under Section 6331, it shall be a levy upon all property and rights to property belonging to such person. No levy may lawfully be executed against me, because I do not have any property or rights to property where such property is subject to a legal or equitable interest belonging to the United States. See U.S. Constitution, Article 4, Section 3, Clause 2. I only have private property belonging to me, which may not be deprived without due process of law, nor taken for public use, without just compensation. See the Fifth Amendment to the U.S. Constitution. Reason number 4. The levy under Section 6331 applies to any person liable to pay any tax. I am not liable, because the alleged liability was established by third-party error or fraud. Walmart Incorporated, McDonald's Corporation, Amazon.com Inc., etc., have each erroneously or fraudulently issued Forms W-2 or 1099 MISC information returns claiming remuneration for services under Section 3401A, wages, or Section 6041A of the Internal Revenue Code, when no such service was ever performed, and no such remuneration or payments were ever made. The IRS is in error because it has relied upon erroneously or fraudulently issued information returns claiming a service, financial interest, or transaction in property belonging to the United States, when in fact no such service, financial interest, or transaction existed. Reason number 5. The IRS has long had the authority to levy by distraint and sale or collect its internal revenue by summary administrative proceedings. See Phillips v. Commissioner, 283 U.S. 589, 1931. However, this administrative, not legal power is a matter of public rights, which must, at a minimum, arise between the government and others. Northern Pipeline v. Marathon Pipeline, 458 U.S. 69, 1982, quoting Ex parte Bakelite, 279 U.S. 438, 1929. That is, when Congress creates a statutory right, such as an entitlement to income, it clearly has the discretion to vindicate that right before particularized tribunals, such as through Article 2, Summary Administrative Proceedings, Phillips, Supra, or in the United States Tax Court, a court established under Article 1 of the U.S. Constitution, see Section 7441. But when the right being adjudicated is not of congressional creation, such as my Fifth Amendment right to private property, no comparable justification exists. Northern Pipeline at 83-84. As the Supreme Court of the United States has repeatedly explained that matters concerning private rights may not be removed from Article 3 courts. SEC v. Jarkissi, Book 603 U.S., 2024. Therefore, if the IRS seeks to adjudicate a private rights dispute, such as the imposition of a debt or the levy of my private property, it must first bring an action in a court of law. They can't do this because they lack the jurisdiction to tax private property, labor, or gains. The jurisdiction over these subjects is fraudulent, as it is acquired through false and non-attributed statements. See reason number 4 above.
Thank you for watching this video. If you have further questions, please see lawfultaxavoidance.com. Know the truth, and the truth shall set you free.